Sweet, big, yeah. All right. So welcome. Thanks for joining us this afternoon. My name is Niki Black. I'm the principal legal insight strategist here at 8am. And I'm also a legal tech journalist. And here on the stage, I have some of my fellow legal tech journalists. And if you're not familiar with um, Bob Roji, who is to the left of me, has a show every Friday at 3 o'clock where he hosts a webcast with a bunch of legal tech journalists, including many of the ones that are here on stage. And we talk about the legal tech issues of the week. So this is sort of a reprise of that show. Except I get to where Bob Ambrogi have to be the moderator and he gets to be on the panel. And what we're going to talk to you about today is a bunch of emerging issues in legal tech and the future of law and how they're going to impact the practice of law. And feel free to ask questions as we go along. We definitely hope that this is an engaging, interactive experience as well. So with that, I'm going to take a seat and let these guys all introduce themselves, and then we'll get started. So first, Bob, why don't you go ahead and let them know who you are?
Well, I'm Niki Black on this panel. I'm Bob Ambrogi. I have a blog called Law Sites where I write about legal tech. I've been doing that for more than 20 years now. Also have the podcast that we do every Friday at 3 o'clock, Legal Tech Week. You can find us on YouTube or on wherever you get podcasts. And another podcast called Law Next, which is just interviews with innovators and entrepreneurs who are driving what's next in law.
Hi, everyone. I'm Steve Embry. I publish the blog Tech Law Crossroads, and I also write for Above the Law.
I'm Joe Patrice from Above the Law, and where we write, Above the Law writes about all things legal, but also, as part of that, legal technology. So I balance my time writing about legal tech with writing about there's apparently a roach infestation at the Kentucky Law School. So I wrote that.
Bring that up.
Oh yeah, no. So it just completely overrun apparently. But I cover a lot of things, but also a good deal of legal tech.
And I'm Stephanie Wilkins. I don't know if you can hear me. I am the director of content at Legal Tech Hub, which is an insight and analysis platform for the legal tech industry. And previously, I was the editor-in-chief of Legal Tech News at ALM.
All right. And with that, we're going to kick this off. We're going to start with a really small question. Will AI really change the practice of law and how I practice law? So I'm going to toss it over to you to start, Paul.
So will AI really change the practice of law? I think it will. I actually think it will. I was reading this week an article at MIT that talked about how we're kind of falling into the trough of disillusionment state with AI. There's been so much chatter about how AI is going to fundamentally change the practice of law and change the way lawyers run their businesses and the way they deliver their services. There has been a lot of hype around AI. I think the fact of the matter is it really is going to change it more than incremental. I mean, every technological, I've been covering legal tech for 30 years now, and every new kind of technology changes how lawyers practice law. But I think this is going to fundamentally change the way lawyers get things done, the way they draft, the way they research, the way they generate documents and any other number of tasks they do. But what it's not going to change is the bottom line of what lawyers do, which is give advice. I don't think that we are anywhere near the point where generative AI is going to change the need for lawyers to do what they do best and give advice. So, Steve?
Yeah, I think it's inevitable that AI is going to change the practice of law. The question, though, is where and in what segment. The legal industry is a pretty segmented business, and AI will certainly change and improve the business end of the practice. I think it already is, as you see from this conference and from the keynote this morning. The substantive end of the practice, I think, will depend on what kind of case it is and what kind of legal specialty is involved. Bet the company cases, for example, may be the last to wholesale adopt AI because in those cases, the client will want no stone left unturned. And that means more billable hours. That's the whole point. So I think it will change. It'll change differently depending on the market segment.
Yeah, I'll echo that. I think it's really going to the extent it's going to change stuff. And I'm a little bit more skeptical of how much it changes things. I think it's going to alleviate and automate a series of tasks, but I don't think it's going to change the fundamentals. But I do think its effect is going to be different based on the matter. I think that there are certain aspects of what lawyers do where this can act as much more of an accelerant than other places, right? Contract management stuff, it can do a lot. Running a case, less so. So I think it's going to matter where it comes in, but at the end of the day, it's just going to be a matter of making a lawyer get through more stuff rather than fundamentally changing the practice.
And I tend to be on the opposite end of the spectrum as Joe. And like everyone's talking about, will it change? I would say it already has changed the practice of law. And I mean, we're just talking about AI. I mean, we've been focusing on like the newest, shiniest iteration of Gen AI, but AI itself is not new. It's been in tools you've been using for a while. Gen AI is even in some things you might be using now and might not even realize it. So it's not changing the way practice is in the way like you can have robo lawyers or it's taking your job, but in little bitty ways already, I think it has changed things. And we'll see that more and more. And as people get more comfortable with it and learn how to use it and harness it in really useful ways to them, not buying into the hype or using it as an easy button, I think it absolutely has and will continue to change the practice for the better.
And by way of context, I feel like I should have mentioned this at the beginning, but everyone on this stage has practiced law. We're all attorneys, practiced in one capacity or another, and ended up on the legal tech journalism side of things, or working for a tech company like I do. But so a lot of our answers also come from that context of having practiced law. So, and I agree. I think it's, artificial intelligence, particularly generative AI, is advancing exponentially, and it's going to exponentially change the practice of law and how attorneys get their work done. And I think that leads into our next question. If it's how is it going to change the practice of law? One area where I personally think that's significantly going to change it is in terms of how we bill, how lawyers bill for legal services. And so the next question really is this going to be the end of the billable hour? Is this the death of the billable hour? Will this finally be the thing that knocks the billable hour into kingdom come? I don't know. But I know that this is a topic that we tend to have very divergent perspectives on. So I'm going to toss this one to you to start off, Steve.
Sure. Well, I come at this having practiced with a big law firm. And so I look at it differently. Logic tells you that it should shift us away from the billable hour. Practically speaking, I'm not sure how much and how fast. And there's a couple of reasons for that. One, most law firms are built upon the business model of the billable hour. Their entire culture is based on billing more hours and doing more work. You advance in law firms by, in part, billing more time. Billable hour quotas in most law firms, most larger law firms. Shifting that to a value-based billing system is not easy because it requires a mind shift throughout the organization, and that's going to take a lot of time. The other factor as well, at least for corporate transactional and litigation work, law firms are working for in-house legal counsel who often, not exclusively, but often come from law firms that bill by the hour. So it's something that they are accustomed to. They feel like they can monitor and track and value the time and work that's done best by using billable hours. So for those two reasons, at least for the big law market and the corporate legal work, I think it's going to take time for the billable hour to end. We've been criticizing it ever since I started practicing law, and it's still here. So we can't underestimate the power of a billable hour.
Like the roaches at Kentucky in there's the walls. But I think I'll add to the practical aspect and say that I think ethically it might have to change. If we get to a point where a lot of junior associate work gets replaced by AI, a lot of work that used to take 10 hours takes 2. Now those are hours that you can't bill for. That's leverage you aren't getting. And at a certain point, because you can't just make up and say, well, it was 2 hours, but we're going to pretend it's 10 ethically. You've got to find a different way to make that money back. And the way in which I think we're probably going to start making the money back is no, not every task can be taken off of a billable hour system, but lots of them can. And as we get more into a situation where leverage is lost and time is lost, there's going to be a push because the lawyers are still going to want to make their money, and they're going to have to do something about it. And this isn't entirely new. I would say that when I was in big law, I was a litigator, but at my biggest firm that I was at, we'd already moved over 20 years ago to like structured finance was all value based. Like all of their work was a flat fee. And the reason for that was they had worked out that those deals took the exact same amount of time over and over again. So they just did that because they could bill at a premium a little bit over the billable hour. So it's been done before. And I think this is the sort of situation that might push it over the edge.
I tend to be the pessimist here that says, the billable hour isn't going away. And it's not because I don't want it to. I mean, I hated living my life billing it by 6-minute increments, right? But I think it's a much more complicated question than just, oh, we want to bill you and we want to pay. The billable hour is so entrenched in the legal industry. I mean, if you start talking about alternative fee arrangements, the math behind that is still like, well, if we think we're going to do this much per hour or this many hours at this rate. And also, especially in big law, you have the compensation incentives for associates. They're still looking to bill their 2,000 hours to get a bonus or whatever. And so that hour structure is still there. There's a whole lot of the system that would have to be dismantled for it to completely go away. That said, I think more and more people in the industry are having the conversations, and I've seen more movement on it, or at least willingness to consider alternative fee arrangements or value billing than I have in the past. And I do think it's an area where small solo mid-sized firms can really make a push because they don't have that entrenched to the level that big law is so entrenched around the billable hour. And it's going to be so much harder to shift away from it. I think that's a real opportunity to offer those alternate billing arrangements and maybe get the leg up for clients that really want it.
Yeah. So my take on this is that lawyers will have to be dragged kicking and screaming away from the billable hour. Lawyers are, notoriously slow to change. I was talking to a woman this morning at a firm where one lawyer still uses word perfect and insists he's got to use word perfect. Lawyers
Maybe in the audience.
the woman may be in the audience. The lawyer is not here because the Pony Express wouldn't deliver him here. But that kicking and screaming, I think they are going to be dragged kicking and screaming because I think the clients are going to demand a different form of billing. The billable hour, it's entrenched, but it's like less than 100 years old. It's not like it's always been that way. And it was originally developed as an efficiency tool, as a way for law firms to kind of monitor, who was doing what, performing, how they were performing. And it's not indelible. It can be gotten rid of. And I think the clients are going to say, look, if you're working that much more efficiently because of these tools, if these tools are actually doing some of the work now that you used to be doing, we don't want you charging us based on your time. Your time isn't what we're paying for. It's that advice. It's for your knowledge. And we have to package the pricing around that somehow differently. So I do think it's going to eventually lead to it, but it ain't going to happen quickly.
Can I make one follow-up comment
for
to
sure.
that? I think the kicking and screaming, and I might add, Bob, you may have been around 100 years ago when the billable hour. Most of us were not, but
Remember,
the thing I was going to point out is lawyers have made a lot of money with the leverage system, where they have one partner and 6 associates busily working on a case, and that way you maximize your profit because there's only so many hours you can work, even in big law firms, and credibly billed for. So you're basically not only talking about the business model, but you're talking about the cash cow, the economic model. And inevitably, if we move closer to AI taking over aspects of the law, that will threaten.
but so small firms can be the avant-garde.
Well, that's true.
revolutionize how-
Yeah, I think that's exactly right. The small firms could end up being the competitive factor that forces the larger firms to shift or they lose work.
But I would also say that, I mean, as some of this billable work goes away and is no longer billable, the work that is billed by the hour, you'll see billable hour rates go up. So the value, the real value that lawyers bring, the judgment, the strategy, the stuff that we're not turning over AI will become even more and higher valued. And if these firms are going to try to make up for the shortfall of the hours, they're going to charge even higher rates for that, what they consider like the real cream work that they're doing. So even though you're seeing fewer billable hours, I think you're going to see hourly rates go up.
And that was the controversial comment that was made at Legal Week, where Lexis said that we were going to see the $10,000 billable hour. I just worry I just think that there's probably, and that is a way in which you could overcome the leverage problem and all. I just think there's going to be a sticker shock moment of we're not paying $10,000 for an hour. But if you package it as you're paying $100,000 for this project, people will still pay for it. So I think I think there's an elasticity moment psychologically where they just will balk at that number.
Yeah, and I'm not necessarily saying the $10,000 an hour myself. I'm just saying higher.
I can certainly tell you that insurance companies ain't going to pay $10,000.
Well, and that's where I think that sophisticated legal consumers are going to come in with the billable hour as well. And the ones that I think of that come to mind immediately are in-house counsel and insurance companies. So people who, outside counsel, I always want to, for some reason, call it outhouse counsel, and that's not what they are. But outside counsel, their clients are in-house counsel. And if you're a law firm that works for an insurance company, they know, they're already scrutinized legal bills, right? And make sure that you're not billing for stuff that you shouldn't be billing on, that you're using the correct codes and all of that. But when you start submitting codes to sophisticated legal consumers, submitting bills that have tasks that they know could have been completed by AI, they're going to push back and they're going to start making sure that you're only billing appropriate amounts for work that needed an attorney's review. And so I think that you're going to start seeing those sophisticated legal consumers being the ones that are really leading this push towards billing in ways other than the billable hour. But the other thing that I think is really going to make a huge difference is when artificial intelligence is baked into the tools that you use to run your firm and bill your clients. Legal billing software and practice management software. And so this morning during the keynote, you heard that we have in beta artificial intelligence that can be used to Q&A your matters right now. And what's coming soon is the ability to Q&A your financial data. So imagine in addition to Q&Aing your financial data to find out who is most profitable or what does our revenue look like, potential revenue for the next month or year or whatever based upon current revenue models. Imagine being able to also say, based upon, we just got a case for this type of case. Based upon all of our data from the last 10 years or however long we've been in business, analyze, look at all the cases we've handled like this, analyze whether it was judgment or settlement, like when did the case come to conclusion, what did it settle at, or what was the judgment, or hourly rates, and how long, and analyze all that data and then tell me what would be a reasonable either flat fee or alternate billing structure, alternate fee structure that would allow us to both be competitive in the market and profitable. And so when you think of it that way and think of the ability to Q&A your law firm's financial data in that way, in addition to not only making it easier for you to be more efficient and provide more efficient legal services, it also makes it easier for you to be profitable with these alternative fee matters. So I think that there are a lot of different ways that artificial intelligence is going to impact legal billing and potentially make the billable hour obsolete, but we'll see. And again, there's a lot of disagreement on that. Another thing that there's a lot of disagreement on is access to justice. Both, is artificial intelligence going to increase access to justice, or is it going to create a two-tiered system where the top of the market is using artificial intelligence to become really efficient, but then it forces more legal consumers to be on their own with AI because attorneys aren't going to handle those matters anymore because they're able to more efficiently handle more complex matters. So I think that's a really interesting question, and it's one that's also up for debate, which is why we wanted to toss it out to the panel. We'll start with Joe this time.
Yeah, I think the answer is both. The AI will take over giving more legal services to people who can't afford human lawyers because it can. That said, it will also, the good stuff is going to be hoarded by the rich clients. And that's just it's going to happen in parallel, I think. The interesting came from at a different conference. There was a session that I watched on this subject where somebody raised an interesting wrinkle that I hadn't thought of. And I still, months later, haven't really come to a conclusion of how I feel about it, which was, to what extent does more AI for, lower income, less legally sophisticated clients actually become more of a detriment. You would think this is help they wouldn't otherwise get. But what this woman who actually worked in the pro bono section of her firm said was, there's a real risk of not knowing what you don't know factor, and that some of those folks are going to they understand when they do their research on Google that they might be wrong. When they do their research on AI, they're going to think this is right, and it may not be. And I hadn't really thought about it that way, but there is a risk of the providing more services. That's a good thing, but does this introduce a form of service that could backfire? And I still haven't figured out whether I think that's true or not.
Yeah, I think there's so much potential here. And that's what every time we have this discussion, the word potential is used over and over again. And that's the crux of it for me, that unfortunately, a lot of this is in the hands of the people with the money, and we're going to rely on them to trickle it down. I mean, Legaltech Hub just worked with the Justice Technology Association to map out the A to J solutions in the market, but also the traditional legal tech providers who are providing discounts, serious discounts or free access to their tools. I would love to see more and more of those. But again, that's relying on the people with the money to do the good thing. But my other thing I trip up on every time this discussion comes up is I feel like this question is always sort of phrased in terms of, will AI fix the access to justice problem? Will close the gap? And no, there's so much to do. I mean, the gap is so big. There's so much to fix. But I think it's already making incremental progress on it. And it's not even just through big tools, even just things like making it accessible to understand how to file that form in court, which usually is so confusing. I mean, and they make it impossible to even access the courts correctly without getting your pleading bounced or something. Things like that, or like even just getting more knowledge in the hands of people. It doesn't have to be the biggest, flashiest thing. I think starting small any progress is good progress. And I think this will get us some progress, even if it's not of the progress we all would love to see.
Yeah, I think I think you made a really important point there, Stephanie. And I think without doubt, AI is going to help enhance access to justice. I think we're already seeing that happening. There are a number of tools getting developed, and they're not just necessarily tools like Joe expressed his fear about, consumer-facing tools that maybe give legal answers. I mean, a lot of the tools that are being developed using AI are in order to help streamline the delivery of legal help to consumers without actually delivering the legal help itself. Like a company called Upsolve, which does bankruptcy, Chapter 13 bankruptcies it's like the TurboTax of bankruptcy for people, totally free. And anybody who needs to file a Chapter 13 bankruptcy can use it. But they were finding that a lot of the people would kind of start going through their process and give up after a couple of screens of filling in information because they found it a little daunting. And so they used generative AI to develop a set of sort of easy, chat tools that make it really easy for people who are going through it to get, how do I do this? Or what do you mean by I need to provide this kind of information? And they found that significantly enhanced the retention or the ability to kind of people to go through the whole process and actually complete the bankruptcy. So it didn't change the product, it just changed the way it delivered it. But the one point I did want to make though is, and something I've written about, which I call we hear about the access to justice gap. The legal tech, I talk about the access to sort of legal tech funding gap, which is that so much of the money that's coming into developing new technology is coming from venture capital firms, private equity firms. We're here courtesy of a private equity funding for this company. But those firms tend to want to put their money into technologies where they're going to see their money come back in spades. And so they want to invest in companies that are serving big law firms or big corporate legal departments. And they don't want to necessarily invest in companies that are delivering legal help to low income people or to small businesses or individual consumers. So there's a potential funding issue. There is already a funding issue. So while AI has great potential in this space, we need more money coming into the space to kind of develop out those products that can serve low-income people.
And another area, sorry, for potential, to keep using that word that I love, is that this is a little bit Pollyanna-ish, but if we go back to the conversation of, AI is replacing all this work that junior associates used to do. What do they do now? Maybe pro bono work. Maybe, you know, if there's so much work out there to be done, when 90% of legal matters don't have lawyers, now that if all these lawyers in theory with free time because AI is doing the low level stuff, put them on the pro bono work. And I understand that's very idealistic, but if even a fraction of that were to happen, I think that could really help too.
And it's not, Stephanie, completely idealistic, except maybe looking at it a different way. There's a principle, economic principle called J. Bond's principle, which basically says if you lower the cost of something, you increase the demand. I saw this. I was at a conference and heard a presentation by someone who had some data that showed plaintiffs' lawyers are filing more cases, and the reason they're filing more cases is they can now take cases where the return might not be as great, but they can take them because the cost of doing the work is now so much less. So there's more cases being filed on the one hand, and then working the case. Um, Lawyers are able to do things with AI that they couldn't do before for their clients because it simply costs too much. Both of those characteristics are improvements in the access to justice, maybe not in the way we traditionally think of who needs improved access, but there are people with legitimate cases who can't bring them because they can't afford a lawyer, and the lawyer won't take the case on a contingency basis because he's simply not worth it. That's changing. And I think, you know, for those of you that practice family law, you all know that there are people out there who desperately want to get divorced and are in a terrible situation, but won't do it because the lawyer costs too much.
Yeah.
We can lower that cost down. There'll be more work, and those people will get served that they wouldn't get served before. So there's a lot of aspects to it.
So AI will need more divorces.
Yeah, that was the takeaway.
Yeah.
Well, and
And just so everybody knows, I am a graduate of the University of Kentucky, where we are now taking in roach borders.
Yep,
So
yep.
if anybody has some roaches
Helping.
you'd like to get rid of, we have a spot for them.
and you know, I tend to think when it comes to access to justice, you just need more funding. I mean, that's bottom line. I think that the funding cuts have been so drastic that really, at the end of the day, you need government funding, and that all the pro bono work and all the technology in the world isn't going to solve it. Because I do think that capitalism trumps altruism every day. And as altruistic as people want to be, AI is not going to solve these problems. But I will say that sometimes this panel travels around to different conferences, and I said that at a conference, and afterwards Jim Calloway came up to me, and he just retired, but for I think 30 years he was the director of the practice management section of the Oklahoma bar. I may have his title slightly incorrect, but he came up to me and he said afterwards, listen, I think you're wrong, because I think that what AI does is it enables the small firm practitioner to take on more cases because it allows them to be more efficient and to potentially not hire somebody at some point and handle more cases and make more money. And he's right. And it made me recall how somebody had emailed me about one of my ABA journal columns after I'd written it very early on in generative AI. And he told me that he was a attorney who only handled assigned counsel cases. And that because of AI, and he was a true solo, he was able to take on more assigned counsel cases than he had before, and he was able to represent his clients more effectively and more efficiently because of AI. And these were just regular generative AI tools without all the benefits of the AI that's built into legal tech tools that's now happening. And so I do think that there's a lot to be said about that in different ways that AI can kind of bridge that access to justice gap, especially on the smaller and solo level in the market, and then at the top levels of the market. And the legal industry report that I authored that we released earlier this year has all sorts of really interesting data, some of it broken down by firm size and some of it by practice area in terms of AI uptake and how lawyers are using and legal professionals are using AI and the benefits they're getting from it. So then the next thing we want to talk about, and this is a really important thing, it sort of dives a little bit into the ethics, but is does AI competence equal tech literacy? And what does tech competence mean in the age of AI? We know that most jurisdictions have said at this point they've adopted the ABA's comments to Model Rule 1.1 that competency also includes tech competency. But what does that mean in the age of AI? And what do lawyers have to do to be competent when it comes to artificial intelligence and meet their ethical obligations in that regard? And Stephanie, you're up.
I didn't know I'd be starting on this one. I would pack my soapbox. I apologize. Um, AI, we've all heard about hallucinations. Who gets blamed for this? It's maybe harsh. Lawyers do. Full stop. This is not a tech problem. This is a people problem. You need to know, everyone in this room, everyone is practicing, if they're going to be using a technology, you need to be comfortable with its limitations. It's just not, your obligations have not changed since ChatGPT came out. You have the obligation to look over anything you file with a court. You have an obligation just the way you would with junior associates, with everything. Like, none of your obligations in terms of what you put out into the world as a lawyer with your name on it have changed whatsoever. And the reality is that AI is here. It's part of the profession. It's only going to be more part of the profession going forward. You have an obligation to understand, at least at a minimum, how it works, how it doesn't work, the problems you can run into. And if you don't know how to use it, educate yourself, learn. We have a couple of states that are increasingly having AI requirements or CLE. I think you'll see more and more of that. And we talk about this every week. Every week there's more examples of lawyers filing hallucinated cases. And we're like, I don't even know what to do anymore. Like, how do we get people to stop it? There's no excuse at this point. Like, it's a known problem. If you're a good lawyer, you don't cut corners just because AI seems magic. That doesn't change that. It's the same obligation you've always had. The buck stops with the lawyer.
Yeah, I don't have even much to add to that. I mean, there is an ethical duty of technology competence. Lawyers have a responsibility to understand both the benefits and the risks of any technology they use. And that doesn't mean you have to be a geek, a technology expert, but you do have to make an effort to understand broadly or generally how these technologies work. Again, what the benefits are. We've been talking about some of the benefits already, but also what the risks are. Yes, this technology hallucinates. You need to understand that. Yes, this technology raises privacy implications. You need to understand that. We don't need new ethics rules to govern AI. We just need lawyers to live within the bounds of the ethics rules that already apply to them and just do, as Stephanie said, just do good lawyering and do it right.
Yeah, I probably have a little bit different view on this, and I'm sure will be disputed a bit. First, with respect to whether we new ethics rules, I do think that what Puerto Rico did, where they basically took comment A, which is the risks and benefits, that uses, by the way, the word should. A lawyer should understand the risks and not must. But Puerto Rico took that and made it a mandatory requirement. The lawyer must understand the benefits and risks, as West Virginia did, by the way, several years ago. But then they also put that squarely within the ethical rules. It's not a comment like it is with the ABA model rules. It is squarely within the ethical rules, which highlights it and perhaps it raises that to lawyers in their practice. I think we do have to understand some of the pressures that could be placed on lawyers. I was at a conference not long ago and having a discussion with a lawyer with a reasonably sized firm, and we're talking about this, and he said, "Yeah, I'm really worried about this, Steve, because I serve as local counsel all the time, and when you serve as local counsel, as many of you know, the National Council does the briefs for the most part, sends you the briefs that may be full of citations, and you're expected to sign it and file it." And this guy was telling me, he goes, "I can't read all those cases that the National Council has cited and expected to be paid for. They won't pay me for that." So that's a concern and that's a pressure. And it's, is the lawyer accountable? Is the local counsel accountable? Yes, but we need to understand the practical reality that we're basically asking these people to be accountable for something for which they may not get paid. And I worry too that clients will, particularly insurance companies who are notorious for trying to shave everything off the bill, are going to say, "Well, we're not going to pay you for reading all those cases that ChatGPT came up with." That would be dumb, but I don't think it's far-fetched to think that could happen. So yes, the lawyer is accountable, but but we also need to understand and try to ensure that everyone in the process knows that this is checking these citations for hallucinations and inaccuracies for that matter. It's not just, there's no case. It's like the cases, there is a case that says, something. It just doesn't say the something you're saying. That's an issue too. And that's going to take time. And we have to make sure that everybody in the process avoids the temptation to say, we don't need to pay for that because it's already done. As we've talked about today, AI can short circuit a bunch of stuff, but we can't just say that's the end of the discussion.
Yeah, I think that's the thing. I think the lawyer is fully responsible now, but we need to consider what's going to happen as this evolves. I think that's the practical implication of more cases, more local counsels, as that problem that Steve's talking about. I think there's going to be a problem where, like I analogize it a lot to when online legal research started, like it pops up with a yellow, with a no flag on it, but like, oh, do you trust that it had no flag on it, or do you go back to the shepherd's books and flip through them? No, of course he started trusting the key citing system, and the key citing system is mostly right. But early on, were people being told your obligation is not to trust that program figured it out and go back to the books? No, like people didn't do that. And that's where I think this is going to end up heading, because over time, we're going to start having systems that check for those hallucinations. People are marketing those. All of these new tools are going to come out, and then there's going to be a threshold moment of, do I trust this tool that is marketed as checking for that? And does it screw up? And like, is it my obligation then? I've done what is, at some point, we're going to have to decide that it's reasonable to trust XYZ, even if it's not perfect, because the volume's just going to get too big as this expands.
Well, and to that point, I mean, associates make mistakes too. Right?
Yeah.
So,
Yeah.
in terms of trusting it, yeah, you look after your associates. You don't necessarily accept everything they've told you, but for first year, it's different than fifth or sixth year, and you begin to trust them more and more. So that there's always going to be risks, no matter what. The question is how reasonable is it going to be?
But there's also a common sense factor. Like if you're a solo or a small and you don't have an associate working with you when you're working on this, like if you go back to like the original Mata via Avianca case, like they couldn't find any cases to support their position. And then suddenly, magically, there were cases in this new technology. Like that doesn't pass the smell test. Like if it sounds too good to be true at a basic level, it probably is. I mean, that doesn't apply to everything, but there are things that can sort of clue you into maybe you should dig a little deeper. Like, oh, I've never even heard of this court, or some of the citations aren't even real courts.
Well, and on that, and the case exists, but it's quoted wrong. There's a real prompt engineering problem going on with some of this stuff where they say, I want a case that says XYZ, and it'll give you a case that's kind of right, but then it will force in the parenthetical being exactly what you prompted it, even though that part is not the case. Right. And the case is kind of that, but it's not that quote. Like that's part of tech competency, understanding if you prompt it that way, it's gonna do its mansplaining as a service thing and give you the answer you want.
But also, I mean, can we just go back to the fact that ChatGPT is not a legal research tool? Like,
Right.
period? Like, that's not where you should be looking for your case law?
Well, and I tend to have a pretty strong opinion about the tech competence issue. I think that all of these hallucination cases that are making the news are just exposing the ugly underbelly of the practice of law, which is that there are significant pressures upon lawyers to bill efficiently, to bill a lot, and what I think what has happened before ChatGPT came along was that, you would say to a friend, "Hey, do you have a motion on this, or have you ever written about this?" Or you would do research on Westlaw, and you'd find filings, from a case that held the same thing as yours. You would just take that motion, and then people would just file things with the court. And when the filings and change names and change dates, when the filings with the court didn't make any sense to the law clerk, the editor, the judge, they would assume that either they typed in the wrong case citation, like one of the numbers was off, or that they misquoted the case for a specific issue, and that it was just sort of sloppy lawyering, but not outright malpractice or negligence, right? But what has happened is that ChatGPT has exposed this. Some lawyers just absolute refusal, or just they're not reading what they're submitting. They're taking these, they're not I mean, if you're going to submit something to the court, you've got to do the research. You've got to read the cases. You've got to make sure that they're being applied properly within the context of the memo that you're writing. And if you have associates or someone else who's doing that, you need to, when you first hire them, read everything. That's what happened when I was hired as an associate. They read everything with a fine tooth comb when I was first hired. And over time, they started to understand that I was competent, and they would, read some of it and, read the entire memo and make sure it made sense and check some of the major cases. But they assumed that I'd gotten to the point in my lawyering where I was a competent attorney. But it took a while to get there. And so you cannot as an attorney submit stuff to the court that you haven't read, or that you don't have the utmost confidence in the person who created this thing, and you haven't read with the right degree, reviewed it with the right amount of specificity, depending on who it is that gave it to you. And when it is software that is known, these tools that are known to hallucinate, I think of generative AI as this cute little assistant that sits on your shoulder that totally wants to help and has a pathological lying problem. Like, you have to understand that it does this. And so you do need to understand the tech, but at the end of the day, you got to carefully review anything that you sign your name, your firm, and you submit it to the court. That's your problem. That's not a tech problem. And so I feel really strongly about that. Next, another topic that often has very much brought up a lot of debate amongst this group is, and it's a very recent one because we all attend the legal tech conferences every year, and the major ones are over now. And what has really popped up as a major theme is agentic AI. There's disagreement as to what it is, and then there's this idea that is depending on how you define it. Is it, a legal assistant that you can rely on, or is it this rogue intern that's completely out of control? And are some of these software companies giving it too much power? And what's the line between assistant and practicing law on your behalf? And so we're going to bounce this over to you, and I'd love to hear your perspective, Bob.
Sure. Start with me, even though Joe's the one who's like, I was attacking it. I was attacking Joe. Joe feels like
and he has to wait for me too.
to downfall of the profession.
And I'm going to talk a lot of that for all those crack.
Should I start with Joe?
Well, no, we can just kind of tee it up for Joe so he can tell us how stupid we are.
And then I'll clean it up at the end.
But I mean, the whole idea of agentic AI is, I mean, it's a form of generative AI, but it's capable of kind of executing a series of tasks to get to an end result and making decisions along the way. It's not just a pure automation or something like that. Like you might say, I need you to generate a certain kind of a transactional document. It may say, well, I need to do some research first. Then given the area of law, I need to research this particular database is going to be the best one. It can make that decision. It can take that information it pulls out and say, okay, maybe I now need to look at some various types of clauses that are appropriate to this agreement. And it can research different sources for that, pull down the right clauses, and ultimately perform somewhat autonomously a series of steps that can lead to an end result. And this can lay out all sorts of different ways, even in some of the AI they were talking about this morning at the keynote, just within, say, my case, it could be able to perform sort of autonomous steps to deliver you an end result about a financial situation in your firm or something like that. And so I think the question that we've debated a lot, and that I think Joe is a little bit in the minority on our panel, is this ultimately dangerous, or does this actually get to the point of almost practicing law or displacing a lawyer's decision making or judgment making? And I don't think so. I think this is a really powerful tool that can, significantly streamline some very common tasks that lawyers do. But ultimately, it goes back to the last discussion about competence. It's still delivering up to you, the lawyer, a result that you still need to review and examine. And the best kind of agentic tools show you along the way that the steps that it's taking and what it's done and the sources it's used and the resources it's turned to. So you're not it's not a black box. You're not in the dark, not knowing how this thing works. So I think it's really powerful, and I think it's appropriate, totally appropriate for lawyers to be using agentic AI.
So I think that the critical phrase in the question is high stakes legal work, because I think that's different than some maybe lower risk, lower exposure cases where using these kind of tools could be very important to move the case along and serve the client. In high stakes cases, I think it's dangerous, and it's dangerous for the same reason that we just talked about with hallucinations. It's very tempting for lawyers just to do whatever the agentic AI suggests and move on without conducting a review and sorting through whether that's a good answer appropriate for the case at hand. I had a case years ago. It was a outdoor concert and the stage collapsed and critically injured several people, killed a couple of people. And one of the defendants just pled in his answer that the victims were contributory negligent. And he was just roasted in the press for that. And his client was roasted in the press for that. I can see an agentic AI tool do it just that, and not somebody not reviewing it carefully or not understanding that in high stakes litigation, it is could be a combination not only of the law, but of publicity and the press and the media as well. And so I think there's some real dangers in that. And so now that I've supported,
I just want to say real quick, I hate the phrase high stakes litigation, because I think to the client, every single case is high
Well,
stakes.
there's that.
It's a high stakes case. And a high stakes just is being defined by it costs a lot of money or there's a lot of money.
Good news, bad news. The good news is you should feel comfortable with agentic AI from legal tech vendors, largely because the bad news, it's not probably actually an agent. I think that the term agentic AI is a sales buzzword that people throw around because it's the hot new thing. True autonomous agentic AI has value, in particular in spaces like cybersecurity, where they have agents where they go out there and they're like, look for incursions. And if a virus shows up that has never existed before, they can figure out from parameters, hey, this looks like something bad. And then they'll figure out a way to kill it without a human in the loop. That's a powerful thing because it saves a lot of time. There's a lot of danger in cybersecurity that quick action helps with. Great. Doing that in law is malpractice. But the good news is I don't think any of the legal tech products that I've seen that call themselves agentic actually do any of that. They mostly are batch files of prompts. Like one that I saw in a legal research context is you put in your file and it will look at it and come up with good defenses and do the research for it and draft you a brief. Well, I could write all of that into a chatbot now. I could put in a file and say, hey, can you look for some good defenses and look for the research and write a brief? That's 4 things I could type in. This thing does it automatically. Cool. But that's not really an agent. That's just it. Put a bunch of prompts in a batch file. And that's great to save me a little bit of time, but it's not this autonomous thing and I think that's important because the autonomous thing is being sold in that cybersecurity model, in the it's going to go out and make your reservations for you model, to the general tech public as this thing that goes all over the place. In law, that's scary. I actually think companies would be better off in this space to just say, it's not agentic, but what it is, it's like a streamlining process that makes things go faster for you. The downplaying it, I think, would actually sell to lawyers better, because if I'm a lawyer, if this really was what is being called agentic in the greater tech world, I'd be very scared. But you shouldn't be about the stuff that I've seen so far in this space.
Okay. So I'm so with you for half of it, and then we wildly diverge. Yes, a lot of what you're hearing being called agentic in legal is not actually agentic. It's just a guided workflow, which we had for a while. If you give it a problem and it already has its entire course mapped out to the end, that's not agentic. That's a guided workflow. Some people are calling that product an agent. It's not. What the agents do is, I want to do X, and they have an access to a whole array of tools. They figure out their own plan. They figure out which tools to access to execute the plan and come up with an outcome without being told exactly what order to do them in or how to accomplish it. They decide that that's the autonomy, the independence that they do it. Where we disagree, and some of those tools do exist in legal currently. You seem to have an assumption that they are doing the final execute button on their own. File it with the court or do the resolution. They don't have to. It's not malpractice for them to run that whole thing. And along the way, they're showing you every step. I don't know if any of you have played around with deep research in ChatGPT. You'll see it I'm now accessing this. Now I'm doing this. Now I'm doing this. So you see what it's doing. And in these legal tech tools, you can intervene and say, no, I don't want you to go that way. Or when it does it, it'll be this is what I've come up with. This is what I've done. It's not going and filing something in court for you. I mean, if you are using it that way, you shouldn't be. The same way you shouldn't just be filing a hallucinated case off ChatGPT. Again, it's common sense. So there are legal tech tools that are using this more agentic architecture, and it's not just a guided workflow. It's very confusing right now because there are some agentic tools called something workflow. There are workflow tools called something agent. a lot more of them out there are not agents than claim to be, but it is real. It is growing. It's not going to be for everything. I think it can be incredibly useful. It's not a magic. I mean, it's on an and it's not like the magic answer to everything out there, but it doesn't have to be like in the cybersecurity sense where you let it do the final step. That makes sense to let it shut it down, but you don't have to let it execute on your behalf. Like you did the example of like make the restaurant reservation. The legal equivalent would be like, and then go ahead and file with the court. You don't have to have that step. You still retain ultimate control over the outcome. It's just it executes the plan independently and does the work and then presents it to you. And then you still are responsible for it.
I completely agree, but that's why I think it's just a batch file of prompts.
But it's not, because it's choosing what it uses.
Well, to the extent it chooses, there was a study, I think it was MIT, I can't remember, that actually went through and tried to work out agents and how successful they are. And it is a copy, to the extent it's making multiple, to the extent there are those that try to make decisions, it worked out that if it is a two-step agent, basically, it's right about 58% of the time. Once it introduces a third step, it falls into the 30s. Like these agents, if you are trusting them to make decisions, they make them badly, and they make them increasingly badly over time as they've been tested by scholars looking at it. That's a thing that when it's making reservations, screwing up a few times is no big deal. When it's doing law, it can be a big deal. And this goes back to the mansplaining as a service comment. Like, yes, it's showing you things, but like the more you get into this sort of stuff, the more psychologically you're going to trust what it's saying, even when it's not necessarily right. And that's that bridge that gets worrisome. So the more we hand over that kind of independent decision making, to the extent it can do that, and I've seen very few that are really going that far. There's a real risk, and it's going to be people who think they're acting responsibly, who think they're looking at it and said, oh, it said it did this and this and this, but it didn't do X that probably was the right thing. It probably should have looked in this other book or database, but didn't, and you screwed up. And it's because you've kind of psychologically trusted it. And that's the deep concern.
Fortunately, lawyers never screw up in that way.
True. I mean, obviously there's skill like that, but if you start using it as a time saver, you might not be, yes, you're looking at the final product to make sure it's right. And maybe it is right, but it missed something else that would have been more right. Those are the kinds of mistakes that I think can happen if it starts going down this road, based on the research I've seen that shows that they keep getting worse the more steps they try to take.
All right. So we're close to the top of the hour, and we're going to close it out with this last question, which is basically yes or no. So everyone keep their comments pretty succinct on this so I don't hold people too long. This one's going to start with Steve and end with Bob. Is there going to come a point in time where using AI, not using AI amounts to malpractice? Go.
Well, there's a very smart and well-known legal tech journalist who once said, not using data analytics may someday be malpractice. That person is here on the stage, and I'm going to say who it is, but but his initials are Bob Ambrose. But I don't think we're any place near to the malpractice point with these tools for a lot of the reasons that we discussed. It's not very that there's just too many holes. Malpractice often is in the eyes of the beholder as well. So, that's going to be an issue. I think the more important question is the ethical question, and it's not necessarily neglect. It's in billing, because as somebody pointed out earlier, there are ethical rules that require us to bill reasonably for the service. And I think the question is, not using tools, does that make your bills unreasonable? That's the question I think we'll be facing sooner rather than later.
Malpractice, probably no, but not best practice, yes. It will come to a point quickly, I think, where for certain tasks like big contract review and stuff, which in the past we used to do like just look at samples and call it good. It's going to get to a point where it's like, but you could have used this to look at all of them, and it's going to be considered bad practice.
Yeah, no,
exactly. For which we won't pay.
Yeah.
Right.
I mean, malpractice is a very loaded word, but AI, even Joe says, using agents is malpractice. I've heard a lot of people respond to that saying eventually not using that will be malpractice. But
that would be very bad, because that would derail the lawyer.
We could fight about this for hours. Joe's wrong. I feel like we put us in disorder for a reason. But no, I mean, maybe not malpractice, but like these AI shows, it goes back to like, I mean, if you're ultimately just refusing to do something that is really efficient on behalf of your clients and then billing them a ton of money and making it less efficient, less accurate, all of the above, that's bad lawyering.
Yeah, I kind of think the premise of the question is wrong because I don't think it's going to be a choice. I don't think it's going to be an option. I think we are getting already to the point where you can't do research without using AI. You can't use so many of the tools that are already on the market without using AI. So it's not going to be, somebody's not going to be able to sit down and say, I'm not going to use AI. It's like the cloud. I mean, it's like mobile technology, it's like all these things. You can't not use them. It's inevitable. So it won't even be an option.
Well, and I agree with that. I look at social media when the book I published with Carolyn Oliphant, PAGA published it in 2010, Social Media for Lawyers. And at the time, lawyers didn't want to hear about social media. And especially for litigators, it got to a point where if you did not understand social media, did not advise your clients about it, did not search social media for evidence, you were definitely breaching the duty of care, right? Like you had an obligation to understand these things. And I think, and at this point with cloud computing, most cybersecurity experts will say that the cloud's more secure than premise-based technology. There was just this huge SharePoint breach that affected businesses and governmental agencies across the country. So, when I wrote the book Cloud Computing for Lawyers, was published in 2012, and back then it almost didn't get published because there was so much pushback. So, and now look where we stand with how people are viewing security and how your data is stored. So I think you're going to get to that same point with AI, except it's just going to happen a lot faster because it is advancing exponentially. So with that, I do want to just thank all of you again for I really enjoy this, the debates that we have, and I hope that they were as interesting for you as it was for me. I love this group, and I want to thank you all so much for attending. And if you have any questions or you want to debate anything like this with us later, we're all around.